Kia ora everyone, hopefully you can hear me from where you are. Tēnā koutou katoa. Thank you very much for joining us at the second AI in Court event. My name is Henry Steele and I'm a partner at Meredith Connell here in the city. As technology continues to evolve, artificial intelligence is playing an increasingly significant role in various aspects of our lives, including in the law. Tonight we'll explore how AI-derived evidence could appear in courtrooms and the challenges it poses. Our hope is to foster thought and discussion about the role and use of AI in the justice system. And we want to do that by providing a worked example of how AI might be used in the very near future and observing how real lawyers and luckily a real judge might approach it. But it's not just us, we're also being live streamed to about 150 people online and recorded to assist with research analysis after the event. Now, this event has been put together by a group of academics, lawyers, and other professionals working in adjacent fields. So before we move to our demonstration, I'd like to, as MC, record our thanks to the various partner organisations that have come together to make these events happen. Firstly, the Auckland University of Technology, the University of Auckland, Victoria University of Wellington, University of Canterbury, New Zealand Police, the Law Association, the Criminal Bar Association, the Courts of New Zealand, and Meredith Connell. We're also very lucky and very privileged to have Justice Blanchard of the Auckland High Court here with us this evening to preside over our hearing, and I'd formally like to thank you, Judge, for very kindly giving us your time. Now, what will happen tonight? Well, today's exercise is part moot and part demonstration. We've invented the scenario, and the AI tool we'll examine does not exist, or at least not currently. The police processes are mostly fictional, although the types of warrants described are real. But while we've taken some license with the facts, the law and the legal framework to be applied replicates that of a real courtroom. We haven't told the lawyers what questions to ask or what submissions to make. We haven't told the expert witness how to answer the questions he'll be asked. We haven't told His Honour what to do or what to say. We've just given them the scenario and the materials and invited them to run with it. We wanted people to be able to come along and see what happens and to use this as a starting point for a discussion about how our law, as it stands, might approach the issues presented by AI. The point being to let us all judge what the right answer should be. And I'll forewarn you that there will be an audience vote at the conclusion of the argument while His Honour collects his thoughts as to whether the evidence ought to be admitted or not. So give it some thought and I'll call on you in due course. I'll talk to you very shortly about the scenario and the facts as they relate to this case. But before I do that, there's a bit of a health and safety briefing. The exits, one behind you, one over my left shoulder, and of course the public exit you came through. In the case of an emergency, it's simply out that exit, down the stairs and through the front door. Bathrooms are out the door and to the left. Now, an introduction to tonight's fact pattern or scenario. Hopefully, you've all got a copy of a couple of documents, a timeline and a copy of Dr. Andrew Chen's affidavit. I won't repeat those in detail, but if you have read them, you will know that police were investigating an online drug dealing account called Pure Goods with a Z. Police used an AI tool called Tracelex to analyse the language from Pure Goods' online post. And Tracelex identified similarities with the language used in Reddit accounts or Reddit threads that seemed to match the defendant, Mr. Popper. Police applied for a surveillance device warrant to investigate Mr. Popper, and the application for the warrant was based on the Tracelex results. In this scenario, lawyers for Mr. Popper are arguing that the warrant was wrongly issued. To issue a warrant or a surveillance device warrant, there needs to be a reasonable grounds to believe that the warrant will obtain information about an offence. So the question is whether Tracelex's results, comparing the language used by the drug dealing account Pure Goods with the Reddit threads, gave reasonable grounds to believe that surveilling Mr. Popper would produce information about drug dealing. Dr. Jen has provided some expert evidence about TraceLex and how it works. And first, the lawyers will question Dr. Chen, and then they will make submissions to the court about whether the warrant was validly issued. The other issue you might hear discussed is whether the law should nevertheless permit admission of the evidence, even if the warrant was invalid. It's our Section 30 balancing test. After the submissions, we will hold an audience vote, as I've said, and then we will invite some comments from His Honour. And then after that, you're invited to join us afterwards for drinks and nibbles in the foyer to discuss the scenario with the participants and with each other. So thank you again for being here. And for the purposes of time, or to make things as efficient as we can, Dr. Chen is already in the witness box and has been sworn in, if he'll come forward. And I'll now hand over to Justice Blanchard, to His Honour, and invite him to take appearances from counsel. Thank you very much.
Right, let's get underway.
Nā koe te kai whakawā, Ms. Brown together with Ms. Gundawa for the Crown.
From Ms. Brown, Ms. Kundua. Good evening, Mr. Perry, Mr. Young.
Could you state your full name, please?
Dr. Andrew Chen.
What area of work do you work in?
I am a senior research fellow in computer engineering at the University of Auckland.
Can you tell us a little bit about your experience in that area?
I've been a researcher in that area for around 10 years, utilizing computer systems, particularly in AI and machine learning.
In this case, we're going to be talking a bit about some software called TraceLex. Are you familiar with that software?
Yes, I've been provided a copy of the software that has been used by New Zealand Police in their investigation of various cases, and I've been able to use that software.
What is TraceLex, just in a general sense?
Yeah, so TraceLex is a piece of software that assists with author identification of text. This is based on lexical analysis, which is a task that humans have been able to do. So we have been able to have human experts review two pieces of writing, and based on patterns in that writing, give it a view on whether or not that writing may share a common author. The software TraceLex automates that process and applies an input piece of text against a large database of text that has been sourced from the open web, and in doing so provides a one-to-many search result.
Do we know how TraceLex works specifically?
So TraceLex is produced by a company called TT Systems in the United States, and they claim commercial sensitivity, so they do not provide any specific details of how their software works. However, we are able to glean some understanding of how it works based on primary usage of the tool, based on secondary resources such as investigative journalism and other media reporting, and also some good guesses.
So you said originally that TraceLex does a job that humans can otherwise do, but it sort of automates that process. Is there anything else that TraceLex does that humans, for example, couldn't do?
Well, humans could do this in that they could do a one-to-one analysis that is feasible, but there are very few experts who can actually do that. So the main thing that TraceLex provides is being able to match input writing against a very large amount of potential writing, which a single human could not feasibly do, and also puts the power of that methodology into the hands of individuals who may not have the technical expertise to do it manually themselves.
Is there a way to know, or how have you been able to determine what or how TraceLex works and what it actually does? What's the, if I start perhaps with what type of AI is TraceLex?
Yeah, so the main clue comes in the name. The lex part of TraceLex is a clear nod to lexical analysis. And so this tool will use lexigraphs, which essentially are a profile of the writing. And so this is looking at things like commonality of using certain words, particular patterns, particular typos as well, grammatical choices, which are often used by an individual subconsciously when they're doing their writing. And so that's lexical analysis, which comes from the name of the tool.
Is there anything other, aside from what is actually written on the page, that TraceLex can look at?
So that there is reasonable research to show that it is likely that TraceLex uses a form of time printing. So this is the notion that people tend to make content or post content at similar times of the day. They tend not to do it when they're asleep. Some people might do it when they're at work, some people don't. And so based on those patterns, you may be able to also further identify a common author. So you wouldn't use this technique for a one-to-many search. You wouldn't say, based on one input time pattern, find which of the many billions of people online that matches. But if you already had a lexicographical match between a piece of input writing and a particular piece of writing from this database, then you might use the time printing technique to further validate that it could have been written by the same person or not.
Are you aware of any other techniques that TraceLex uses or might use?
So there have been some claims that TraceLex uses author profiling. This is a slightly distinct field of study where, based on the way that something has been written, you may be able to discern demographic or psychographic characteristics about a person. So, for example, being able to identify that something was written by a 15 to 25-year-old female, for example. That has been asserted by investigative journalists who have looked into the way that this tool works. In my professional opinion, this is not likely to be a useful technique for TraceLex because it would point to a group of individuals rather than to a specific individual, which is the main value proposition of the TraceLex tool.
When text is put into TraceLex, what does it compare it against?
Yeah, so TT Systems offers a database, which is largely content that has been scraped or collected from the open web. So that's the internet and anything that's publicly accessible.
So in this case, we have some Reddit profiles. How much of Reddit would TraceLex be able to look at?
We don't know the answer to that. Probably, anything that's public. There may be closed communities on Reddit. There may be communities that might be behind some sort of a filter, 18 plus communities, that sort of thing. So that might not be in the data set, but we don't know for sure.
What kind of output do you get from TraceLex?
Yeah, so TraceLex will show you, given a particular piece of input text, the output text that it thinks it is matched against, and it will produce a confidence score. So a confidence score is a value between 0 and 100 that indicates the confidence of the tool that the provided output text matches the input text that you've provided.
What's a good confidence score versus a bad confidence score?
Yeah, so the user manual for the tool indicates that a score above 75 would be very good. So this is accepting the one sort of edge case, which is that if you put in content that is already online, then you would expect a very, very high confidence score because it's essentially able to find an exact match. But in most normal cases where you're putting in text that is not online from an unknown source and comparing to what is online, then a score above 75 would be considered very good. Fewer than 10% of matches would be in that category.
So a confidence score over 75, is it a sliding scale? So a confidence score of 80 is better than 75. Is that how that works?
Yes, higher numbers are higher confidence. Yeah.
What would be a exact match confidence score?
In theory, it would be 100, but given the way that these systems are built, there will always be some element of probability involved. And in fact, if it were to deliver a score of 100, you would probably be quite suspicious of that result. So 99 would be quite good.
Have you done any testing of TraceLex?
Yes, so after being given access to the New Zealand Police version of this tool, I conducted 3 experiments, or a series of experiments that were to demonstrate the way that this tool might be used in slightly different contexts. Would you like me to go through those in detail, or any particular experiment?
I think we might leave those experiments, and if my learned friend wants to go into those in some detail, then he can. Is there any way that, for example, I think in your experiments, did you identify any problems with it in terms of the amount of input text that it would receive?
Yeah, so generally more input text would lead you to a better result. And I suspect that this is just because the system has more material to work with. So it may not be that more material equals better performance, but certainly less material leads to worse performance.
Those are all of my questions. Please remain there for some questions.
Thank you. Good evening, Dr. Chen. Could I just ask you a couple of questions first? You mentioned that you yourself had undertaken some testing of this product, but I note past that you've only referred to investigative journalism content. Can I take it from your evidence that there's no peer-reviewed scientific testing that's been carried out on TraceLex?
Correct. I was not able to find any published peer review studies. I believe that some of the police forces may have done their own investigations of this tool, but those were not available to me.
Just clarify, when you say police forces, you don't mean the New Zealand police?
No, internationally.
You obviously carried out your own testing, but you were brought in, I suppose, for the purposes of this argument, weren't you?
Yes, so I believe after all of the events that are detailed in the case had occurred, I was brought in as an independent expert to evaluate the tool.
So there were no tests carried out by New Zealand police prior to this tool being deployed in the field?
None that I'm aware of.
I'd just like to ask some questions about TraceLex itself and how it functions. In terms of how it's used by the New Zealand police, does it run locally, or is it cloud-based?
That's a good question. That is not answered in this statement. It is probably cloud-based.
Okay. Well, I suppose one of my questions is that if TraceLex is cloud-based, is it possible that the underlying algorithms or configurations of it could be changed or updated by the developer without knowledge of the user, in this case, New Zealand Police?
Yes, that is certainly the case. It would be relatively common for tools of this type to be cloud-based, particularly to protect the commercial sensitivity around the intellectual property. And that would mean that, yes, the developer or the owner of that system could make changes without notification.
So is there any guarantee for a user of this that a query run now would return the same result in 12 months' time?
No, we could not guarantee that.
And am I right that that's sort of a common theme with AI products, isn't it? That due to their probabilistic nature, you're not guaranteed to get the same result if you run the same query twice.
Correct. I think depending on the system, you could run a query a minute later and it could produce a different result. So it would depend on the probabilistic nature of the system.
It may also depend, wouldn't it, on the scope of the material which the system is considering?
Yes, definitely. And for a product like TraceLex and the sort of open source database that they're using, we would expect that to grow over time as they're collecting more of the material that's online. So if you were to run a query today and a query 6 months from now, it would be operating against a slightly different database.
But that's not something we would be able to know as the user, would we?
So TraceLeaks releases sort of changelog notes. So they release versions and they indicate what's changed in those versions. But I guess technically speaking, there would be some degree of trust that that information is correct.
I have a couple of general AI questions for you. I think you're probably qualified to answer them, but could you explain the concept of hallucination as it relates to AI products?
Sure. A hallucination in a AI, particularly a generative AI product, refers to the concept that these Gen AI systems will sometimes select words that are incorrect. Essentially, that they will make errors. But the key characteristic of a hallucination is that it appears highly convincing. So that in the context of the answer given, it otherwise appears correct. So essentially, it is an error where the system has produced something that's wrong, but it appears correct.
Sort of flowing from that, there's a concept in AI discourse, isn't there, known as human in the loop. Am I right?
Correct, yes.
What does that refer to?
Essentially that with any of these AI systems, you take the output, a human will be the one that makes any decision that is based on that information. So not allowing for fully automated systems where the AI makes the decision.
Would that be considered best practice?
Certainly in a law enforcement context, I would expect that to be the case, but I'm a technical expert rather than a legal expert.
Could I ask you now about the testing that you carried out? And I can probably move through them fairly quickly, but you carried out 3 experiments, didn't you?
That is correct.
And experiment 1 involved matching writing to individuals who had a large amount of academic or media writing already available online.
Correct, my colleagues in the lab.
And when you carried out that experiment, you found it to be highly accurate, didn't you?
Yes, and that would be expected because there is a lot of publicly available writing available for these people, and the input writing samples that are put in were of the same style.
So would you consider that that particular scenario to be optimal conditions for the use of TraceLeaks?
Yes, that is essentially what I was trying to demonstrate with that experiment, was that if I could put in that type of material and the confidence score was very low, then that would call into question the effectiveness of the tool, but it performed as expected.
Now, you did two other experiments. One involved police recruits. In terms of the amount of public writing those recruits had, there was much more limited, wasn't it?
Yes, it would be expected that as ordinary members of the public, these individuals had less formal writing available on the open public web. And so when putting in essays that they had written for the police college, there was less to match against on the open web.
And what were the accuracy results like in that one, the second experiment?
Yeah, so in that second experiment, the most likely author was only identified correctly in 2 of the 12 cases, and with very low confidence scores generally, low enough that they should be dismissed out of hand.
And the third experiment, I understand, involved using writing samples from a group chat of rugby league players, correct?
Yes, correct. A group chat that I am in, and I asked the other participants if I could use their material for the purposes of this experiment.
Again, that involved short form, informal writing samples, didn't it?
Yes, yeah. So I tried to find a situation that would be as similar as possible to the facts of this particular case without using any real information from the police.
How was what was your view of the accuracy under those conditions in that experiment?
My overall view was that the system probably performed better than I had expected, given that the input text was relatively short and limited, given that only some of the individuals had more public profiles and had writing available online, that I expected that there might be a difference between the way that they communicated in a group chat, in a private group chat, versus how they might write when in content that is otherwise published online. But the tool was able to identify 7 of the 10 authors correctly.
7 out of 10 were identified correctly, and one of those was an individual with a significant amount of long-form public writing, wasn't it?
A journalist, correct.
And so would it be, I suppose, drawing together your results on that, would you agree that if optimal conditions are, there's a lot of long form formal writing, those are optimal conditions. Suboptimal conditions are where communications are short form and informal.
Correct.
Would you agree that your results in experiments 2 and 3 showed that when there is, when the product is used under suboptimal conditions, there is at least a material risk of misidentification?
I would agree with that assessment.
Okay, thank you, Dr. Chen. I don't have any further questions for you.
Examination? All right, and I don't have any questions, so thank you, Dr. Chen. Brown.
Thank you, Your Honour. This is an application by the Crown that for a ruling that evidence obtained pursuant to a surveillance device warrant is admissible at the trial against Mr. Popper. And the key question for Your Honour is in relation to Section 30 of the Evidence Act as to whether or not this evidence was improperly obtained. The Crown's submissions will be in 2 parts. I will address Your Honour on the legality of the surveillance device warrant, and Ms. Gundua will address Your Honour on the Section 30 balancing process. But I will start with that legality of the warrant. And it should come as no surprise that the Crown's central position is that the surveillance device warrant was validly issued. The key question is this: should we allow the use of an AI tool like TraceLegs to help the police to do things that are beyond the scope of ordinary humans to do? And I say the answer to that question has to be yes. It has to be yes, because as technology develops, so must we. And that has always been the case. Artificial intelligence is just another way that the police can keep up with our increasingly digital world. And what's important to remember in this case is that this is not really generative AI. This is not an AI coming out with fake case names and hallucinations. This is an AI that is performing more of a scientific task. It's going behind the scenes. It is reviewing vast quantities of text that no human could possibly ever review, and it is giving a result from that.
But how do we know that it's not coming out with fake information?
Because in this case, it didn't.
That's looking at it with hindsight, though. Are we allowed to look at it with hindsight?
Well, if we look at the surveillance device warrant application, we can see what actually was before the issuing officer when they were considering whether to issue the warrant, which is what Your Honour should be looking at for the purposes of this. That issuing officer before them had an application that set out the TraceLegs output, which said, here are 2 Reddit profiles that have a very high confidence score that very likely to be the same person as Pure Goods. The police then had someone review that. And those people said it is likely to be the same person. Now, there is a difference between likely and very likely, but in my submission, it's not sufficient or not as much of a difference to be a problem when it comes to reasonable grounds to believe that you've got the right person.
Is there a risk of something like confirmation bias when you have the computers already made a decision and then you have people coming along afterwards and confirming it?
Certainly, but I think that would call into question the scientific rigor of the people actually doing that confirmation. And those people as experts would hopefully be aware of the risk of confirmation bias. I would liken it to, for example, this is a much more simplistic example, but I would liken it to using a calculator to do a complex equation. Long division, etc., is not my strong point. But if I put something into a calculator and I get the output and it's the right number, then I can go away and I can do it in long form to double check that the calculator did it correctly. It's going to take me a very long time, etc. And there's always the risk of confirmation bias there too. But I can look at my method and I can say, well, I forgot to carry the 1 there. And then maybe I'll see, maybe I did have confirmation bias and I got to the wrong result or something similar to that. But in my submission, that is an inherent risk in any scientific process where you have used a tool, whether it be a simple calculator or an AI lexicographical profile, that risk is just going to be there. And I think in my submission, that's something that we need to accept as a risk when we have technology that does things that are more advanced than we are. So essentially, Tracelex is doing what humans could do if they had infinite time and infinite intelligence, really, because it's also collating a lot of information. Your Honour heard from our expert that it's not only looking at syntax and how slang and things like that, but it's also looking at when things are posted, the response time, things like that. And all of that was in the surveillance device warrant application as well. An explanation of that was in there. So I accept as well that Tracelex does not disclose its methods for actually doing this work. But in my submission, that's cured in this case by the fact that the police have gone to verify those results. It's also assisted by the fact that they've looked at those 2 separate Reddit profiles and they have both looked to be from Mr. Popper.
It's not a very definitive connection, though, is it? I mean, a reflection of a person in a car. I mean, you can't really tell it's Mr. Popper.
That's a little simplistic, I think, Your Honour, in terms of what the evidence was in relation to that profile, because yes, it's easy to say, well, there's a partial reflection in a window of a photo and therefore we think it's a Caucasian man in his 30s and therefore it's Mr. Popper. But there's more than that, because Mr. Popper's first name is Philip and the name of that Reddit profile was Philly Geestake. Mr. Popper lives in Auckland. The user of the Philly Geestake user had a vehicle that was rented from a car rental service in Auckland. So there's a little more than that. He also has his Facebook profile, which or his Instagram profile, where his name is Philly P. So he's using the name Philly regularly across different platforms. And so in my situation, it's not just on police aren't simply relying on the fact of a partial picture in a window. There's more than that links to Mr. Popper. But crucially, it's the other Reddit profile that links very clearly to Mr. Popper. And that's the one with the power bill in a screenshot that has his name and full address there. So we're not looking at 2 isolated pieces of information. We're not looking at Tracelex coming out with a result and one Reddit account somewhere that it says, and we rely on it, that that's the same author. We've got Tracelex coming out with something, people independently verifying that they also think that it's likely, and then 2 Reddit accounts that cross-reference to one another as being from the same author. So we have, in my submission, or at least the issuing officer had in my submission, quite compelling evidence and a basis on which to issue the surveillance device warrant. And that's really my submission for saying that it was lawfully issued. I've really come, I think, to that's the point of my submission, really. That's the high point, and I really can't take it much further than that. What my submission is that the police should be able to make use of new technology so that they can better investigate criminal offending and protect our community.
I don't have any difficulty with that at all. I think that makes total sense. The issue in my mind is just how reliable it is. I mean, I can totally see the advantage of this kind of technology, very powerful. It's just we need to be sure about the reliability. And I suppose my concern is we don't have a lot of information about how this product has worked in practice because the vendor hasn't provided any information, and so we're having to rely on secondary sources.
Yes, and the reliability, though, in this case, is what has been tested, really. We can see from the surveillance device warrant application that the reliability was checked. And having a human source say, thanks very much, tool, you've given me a great place to start, and now I'm going to go and use that to further my investigation. In my submission, that has been set out fully in the application, and that was information before the issuing officer, and it's a perfectly solid basis on which to issue this warrant, which then ultimately, Your Honour, was identified the correct person. If there's ever an endorsement for the accuracy of the tool, then this is it. So with that in mind, Your Honour, Ms. Gundawa will address Your Honour, on the Section 30 balancing exercise. As she does, I do request that Your Honour bear in mind the key point here, which is that bringing this prosecution to an end, because an AI tool did its job properly, would not be a feature of a credible system of justice. And so with that, Your Honour, I'll hand over to Ms. Gundawa.
Thank you, Ms. Brown. Ms. Gundawa.
I'm going to address Your Honour on the Section 30 balancing exercise. The Crown's respectful submission is that the exclusion of this evidence would be disproportionate to the impropriety in the present case, and therefore the evidence ought to be ruled admissible. To do so, I'll be working through each of the Section 30 factors in turn. Starting with the first one, the importance of any right breached by the impropriety and the seriousness of the intrusion. The importance of the right is not in dispute. It is, of course, an important right to be free from unreasonable search and seizure. However, it is also important to note that the surveillance device warrant issued was on Mr. Popper's car and not on Mr. Popper himself. And also, while the warrant was sought for a 30-day period from the 20th of August, it was only used for 10 days on the 29th of August when the controlled delivery took place. So yes, the right is important, but there was no intrusion of it in its highest degree. The second factor is the nature of impropriety, in particular, whether it was deliberate, reckless, or done in bad faith. The most important feature of this case is that this impropriety was not done deliberately, not done recklessly, and not done in bad faith. TraceLex is a tool that is useful in narrowing down larger sources of publicly available information. And the use of this tool was done in good faith, with good intentions, and to complete a job that would take humans infinite resources and time. And the use is permitted under police policy. Therefore, there is no basis to say that this impropriety was deliberate, reckless, or in bad faith. And this factor weighs in favor of the admission of the evidence. The third factor is the nature and quality of improperly obtained evidence. So this evidence that was obtained through the tool and the subsequent activities and evidence that took place after is central to the prosecution. Mr. Popper the admissibility of evidence is determinative of the prosecution in either direction. The fourth is the seriousness of the offense with which the defendant is charged. The offense in this case is a Class B drug offending. The maximum penalty is 14 years imprisonment, and Mr. Popper was dealing with this on a commercial scale on a leading role. The offense is therefore serious, again a factor weighing in favor of admitting the evidence. And the next factor is whether there were any other investigatory techniques not involving any breach of the rights that were known to be available but were not used. It could have, and without using this AI, without using the TraceLex tool, it would have been impossible to identify, or very, very difficult to identify, the person behind the pure goods profile. And to do so, we would need a team of expert linguists with time and their resources to understand the people behind the distribution ring, or even searching for them on the internet or all of Reddit, all of publicly information available on Reddit. And simply doing the controlled delivery, without investigating the pure goods profile also had the potential of jeopardizing the investigation by alerting the targets to police attention. So this factor also ultimately weighs in favor of the evidence being admitted. The last three that were there, whether there are any alternate remedies to the exclusion of the evidence that can adequately provide redress to the defendant. It is accepted by the Crown that there are no alternative remedies to the exclusion of the evidence. And finally, the last two criteria, namely of urgency and any apprehended physical danger, are not applicable in this case. So in light of the factors outlined above, exclusion of the evidence would be entirely disproportionate to the impropriety in the present case. While the Crown's position is that the surveillance device was lawfully issued, should Your Honour reach the Section 30 balancing exercise, the correct outcome in the Crown's submission is that the evidence should be ruled admissible. May it please Your Honour, those are the submissions of the Crown.
Thank you. All right, Mr. Parry.
Thank you, Your Honour. I'll just start by noting the structure of the defence submissions will follow the same structure of the Crown. I'll address Your Honour on the unlawfulness of the warrant. Mr. Young will address Your Honour on the balancing exercise. I want to start by agreeing with my learned friend from the Crown, because I do agree that police should absolutely be using technology to assist in their work. As someone who's before the court with a laptop and a smartphone, I think we all should. But the point is they cannot ignore the limitations of the technology that they are using. They cannot bolster weak evidence by saying that it came from this very sophisticated, shiny new toy. And what my friend has said is that we should not bring this case to a close because the AI did its job properly. Putting aside whether it did or not, I'll address Your Honour on that separately. What this case is really about is the police not doing their job properly. So to err is still human.
What do you say the police should have done here?
Well, what the police have done here is they have used a method of questionable, or at least very poorly understood, reliability. They've failed to corroborate that in a meaningful way, and I do want to make some submissions specifically on that. They've then provided that output to an issuing officer without disclosing any of the underlying limitations. And I think what was very clear from Dr. Chen's evidence is those limitations are there. They're not below the surface. They're very very obvious. The structure I'd like to walk through, Your Honour. First, I want to talk about reliability of the AI, specifically in this case.
But that's really the key thing, isn't it?
Well, I think there's two things. There's the AI, and then the point that Dr. Chen discussed, the human in the loop.
Yeah.
So the AI has produced an answer for us.
Yeah.
We then have a human at the end of it saying, it has spit out this answer. Is this something that we're willing to sign our names to? Can we say that given what we know here, given the other evidence around it, do we have reasonable grounds to believe that if the search warrant is issued, it's going to turn up relevant information?
Right.
So as far as reliability goes, there's actually two types of unreliability here. There's what I would refer to as inherent unreliability, which is the features of the system itself not being well understood. But there's also the specific unreliability in terms of how it was used in this case. So inherently, as Dr. Chen noted, TraceLex is a black box system. It works under unknown conditions, weightings, algorithms, and it still has a known error rate. We don't know the specific algorithms used, how that changes. We don't know what the confidence scores mean other than higher is better.
Well, does that not give us, I mean, the system's got this confidence score built into it. Does that not give us some assurance that the system itself's telling us that it's confident?
It is, but it seems to depend. It depends on what conditions the tool is being used under.
Is that what you draw from the 3 tests that Dr. Chen did?
Yes.
That the confidence scores are not reliable?
I think the confidence scores are difficult to understand. The confidence scores are not percentages. They don't correspond to the probabilistic language that police use.
I think they are percentages, aren't they? Are they not?
I don't think they were.
They're out of 100, I think. They're close to percentages.
I suppose linguistically,
Yeah.
percent.
Yeah.
Then yes, but we don't know. I mean, for instance, we don't know if an 85 is 5% more. I mean, does this work in the same way as, say, decibels or Richter scales, where 5 more is a lot more, or 5 more is not much more? We don't know these things because they're not disclosed to us by the manufacturer.
Right. There is a document here, but maybe it's a police document that does talk about a scale. I think if you've got the police, the drug interdict report at the final on the final page. But as your interpretation, that's something the police have produced, not something that the supplier of the software has produced.
Yes, that's a police intelligence tool,
Right.
and that those terms correspond. The terms used in that table correspond to some of the terms used in the profile.
Right.
I'll come to when I discuss the corroboration. 2 more points. Firstly, Dr. Chen's evidence that there's no guarantee that we're going to get the same result if we run the same query again, either now or later, is one of the features of AI tools, which are probabilistic. Secondly, in terms of the conditions that this was used under, there were 2 categories which I proposed and to which Dr. Chen agreed. There was optimal conditions and then there were suboptimal conditions. Optimal conditions being where there was a large amount of publicly available long-form formal writing. Suboptimal when there was short-form informal writing or smaller amounts of it. We're dealing with the latter in this case.
What about the rugby league players experiment? That was the one that Dr. Chen said was the one that he thought was most like this one. That seemed to produce quite good results.
Well, it depends how you feel about quite good.
Right.
Because what Dr. Chen actually said was he had 10 individuals. It identified 7 of them correctly, and one of those people had a large amount of publicly available formal writing, which leaves you with 6 out of 10 correct identifications. 6 out of 10 is not at the standard of reasonable grounds to believe. 6 out of 10 is more likely than not. So there were suboptimal conditions used in this case. In particular, the second account name, which has slipped my mind. Anyway, the second account, the one that had that matched to the power bill, had a very small amount of posts alongside it. But moving along from the concept of reliability, the real point here is the lack of corroboration. Now, human in the loop, as Dr. Chen said, the results have come out of this AI product, and they've then been given to experienced open source intelligence analysts from the police.
But isn't that what you'd want to see? To see that the experts are verifying the information?
It's precisely what I think we would want to see. Although I know Dr. Chen wouldn't be drawn on whether that was best practice in this case. my submission is that that should be best practice in a case like this, that the results should be checked. What those analysts said is that it was likely, and that word is italicized in the intelligence document, it was likely that the Reddit accounts and the Pure Goods account could share the same author. And that's where we come to the table of probabilistic language at the back there.
Right. Oh, I see.
Likely-
That's where that comes in.
Yes,
Yeah.
so in the intelligence setting, likely has a very specific meaning, which is more likely than not to occur or be accurate. So what we have is that finding is still short of the grounds required to grant a warrant. That is still short of credible and objective evidence to believe that something is the case.
And I think the police also acknowledged the difficulty for humans in carrying out this kind of exercise.
Absolutely, absolutely. But despite the inclusion of technology, this comes down to a very old-fashioned proposition, which is the evidence that we have, is that good enough? And the defence in this case says that it is not. Those are the key points that I wanted to make, Your Honour, in terms of reliability and the lack of meaningful corroboration. Defence submission, obviously, is that the threshold of belief was not met and that the warrant was unlawfully obtained. Unless Your Honour has any further questions for me, I'll invite Mr. Young.
No, it's very helpful. Thank you.
Thank you, sir.
Your Honor, I will address you on the Section 30 balancing exercise. The defense position is that exclusion is the only proportionate response to the impropriety. Section 30, subsection 5A, makes it clear that evidence is improperly obtained if it is obtained in consequence of a breach of an enactment by police or another public authority. If the court finds that the surveillance device warrant was unlawfully issued for the lack of reasonable grounds, as my learned senior has addressed, then the warrant was issued in breach of the Search and Surveillance Act. And any evidence obtained in consequence of that breach is improperly obtained, that being the fruit of the poisonous tree. The warrant in this case, which was primarily based on TraceLex AI analysis, directly led to the controlled purchase, the search of Mr. Popper's home, and the seizure of the drug evidence that's before the court. The chain of causation is so intact, and therefore it is the defense position that any evidence gathered through that warrant was improperly obtained. I now wish to draw Your Honor's attention to the balancing factors under Section 30, subsection 3. Turning first to the importance of the right that was breached. The right breached here is the right to be free from unreasonable search and seizure. This is a fundamental privacy protection under Section 21 of NZBORA. And covert vehicle surveillance is a significant intrusion into a person's privacy. That intrusion here was authorized based on this untested and opaque AI tool with acknowledged accuracy limitations, as we have heard today. Using such a tool without proper testing before deployment undermines this constitutional safeguard and heightens the seriousness of the breach in this case. And therefore, this factor should favor exclusion of the evidence. I now turn to the nature and seriousness of the impropriety in this case. As I have submitted before, the warrant was based primarily on the TraceLex analysis, which, as my learned senior has addressed, is unreliable, both inherently and specifically to the facts of this case. It was an untested investigative method with acknowledged accuracy limitations, and police relied on its output at face value without transparent disclosure of the limitations to the issuing officer in the warrant. They have therefore failed their duty of candor. That's at very least reckless conduct in seeking intrusive surveillance powers without robust independent verification and failing to disclose the limitations as they should have done. The policy concern here is a straightforward one. Police shouldn't be able to get surveillance warrants based on the output of an opaque and untested AI tool with a known error rate. TraceLex itself accepts that even scores above 75 can be rounding up to 10% of the cases. That is far too high. If we look at an actual application of the tool, like Dr. Chen's third experiment, where he used the rugby league posts and applied the TraceLex analysis, well, it did identify correctly 7 out of 10, but as my learned senior has addressed, one of them had a large publicly available amount of writing. So the actual correct identification in circumstances that's most similar to this case is only 6 out of 10. 6 out of 10 is only just more than a half. It's more likely than not. The room for unreliability is still too high. It cannot be the principal basis for justifying a massive intrusion into someone's privacy that a surveillance warrant can represent. If the police can do that, the door will be wide open to wrongful identifications, as Dr. Chen has accepted, and that will lead to wrongful arrests and the loss of public trust in the police.
Does it matter? Sorry, Mr. Young. Does it matter that in the end it looks like the police got the right person? Does that matter?
Well, yes, Your Honor, it matters in this case. However, the defense position is that we should be looking beyond just in this case. It may have been correct in this case. However, as I have submitted before, the accuracy limitations are there. The chance for incorrect identifications is still moderate to high. And this case highlights the importance of ensuring that the use of unreliable AI tools, such as this one, as the basis for authorizing significant intrusions of privacy, must be firmly disincentivized.
And I suppose we can expect the police to be using this tool quite a lot now that it's available, and it looks like it's very useful. And so does that lead you to think that that I need to be careful about this?
Yes, Your Honor, that's precisely why we have to be more careful with this tool, because as my learned senior and Dr. Chen has stated today, the room for incorrect identification is still there. It is at least 10%, which still, we take this to the highest level, we'll get still 1 out of 10 per people that will be identified incorrectly. And this cannot be the principal basis to authorize surveillance or arrests. It is far too high. It opens the door too much. That is the defense position.
Right, thank you. And I think,
And
sorry, did you want to add something? Yes.
And the defense position is simply untested technology such as this one with a black box analysis that's not properly understood, with a moderate to high accuracy limitation. It cannot be substituted. It cannot substitute for proper and lawful investigative means. And therefore, this factor should point in favor of exclusion. I will move on to the nature and quality of the evidence obtained. We acknowledge that the evidence obtained was highly probative. However, when this is combined with reckless police conduct, not disclosing the limitations of the tool in the warrant, despite the high probative value of the evidence, it should nonetheless be excluded. Admitting important evidence that was obtained in breach of fundamental human rights, it will risk creating an incentive for the police to act in disregard of human rights overall. It will give police the false confidence that important evidence will be admitted anyways, despite being properly obtained. And excluding the evidence here would make it clear to the police that high probativeness of the evidence alone cannot be used as a shield for police conduct, for reckless police conduct, and uphold the deterrent purpose of Section 30. Next, I will address the seriousness of the offense. As the Court of Appeal in Underwood and the Crown has established, seriousness of the offense is assessed evaluatively, looking at all the relevant circumstances of the case. And the facts here would place the offending at a moderate level at most. While MDMA supply is an inherently serious offense, it was a small scale and local distribution, and there was no evidence of large scale trafficking or plans of expansion. There was no violence, no weapons, and no heightened public safety risks. In these circumstances, a moderate seriousness alone cannot justify overriding fundamental rights. It cannot excuse the reckless manner in which the evidence was obtained. The second to last factor is any availability of alternative investigative methods. There was no evidence that less intrusive techniques were considered or tried first. The police straight away deployed a highly invasive technology, covert surveillance, as a first resort and not a last resort. Lastly, I will address Your Honor on the remaining factors of urgency and necessity. There was no urgency in obtaining this evidence, and the impropriety was not necessary to avoid any apprehended danger. And police had the time and opportunity to take a more cautious approach to investigate this crime, instead of deploying surveillance based on an unreliable AI analysis. Your Honor, when all these factors are weighed, the defense position is that exclusion of the evidence is the proportionate response to the impropriety. The evidence should be excluded, and to admit the evidence would to erode the protection of the right to be free from unreasonable search and seizure, lower the standard for deploying highly invasive surveillance, and give police the wrong incentive that AI tools, unreliable AI tools such as this one, can substitute proper investigation safeguards. If Your Honor pleases, that concludes the defense submissions.
Thank you very much. All right. I think you've done perfectly on time. Well done. Thank you.
In your hands now, sir.
Well, I'm happy to provide some remarks. Do you want to do it that way around? All right. I don't think that's what the program says, but all right. I'm not going to give an oral judgment, but I'll just give a few thoughts on the case. So just on the first issue, I mean, the fundamental problem is that you're dealing with a black box. So you can't look into the system to determine whether there's the necessary connection. And you can't judge whether the process that the system's following is a reliable one. So you've got to judge reliability by some other means. This didn't really feature in the argument, but in the material before the court, there's been a suggestion that TraceLex is could be seen as being akin to an expert opinion on handwriting. I can see why someone might look at it that way, but I don't find that particularly helpful as an approach. The other approach that was suggested was that the case law relating to anonymous informants might be helpful in this context. And there is a similarity in that it can be difficult to assess the reliability of anonymous informants. And the Court of Appeal have said that there has to be some accompanying evidence in the application to suggest why the information should be considered reliable and why the informant's assertions are solidly grounded. So evidence of an informant's reliability could be that the source has supplied reliable evidence in the past, or that the part of the story that they gave has been confirmed by other police inquiries. So if we took that approach in this case, the two questions we could ask are, has TraceLex supplied reliable information in the past, and has TraceLex been confirmed by police? Have the results been confirmed by police inquiries? I mean, one approach that I thought about was just to look to see what TraceLex is understood to be doing, and Dr. Chen's evidence was very helpful on that. The material provided to the court indicates that TraceLex generates a lexicographic profile or lexicograph, and specific authors have specific patterns in the way that they write. This is in terms of words used, punctuation, grammar, sentence structure, and writing style. And Tracelex is able to compare the lexigraphs of one information or one account with others, and that's an explanation I can understand. It makes sense to me, and it's also consistent with what Dr. Chen said in his affidavit regarding the way that modern AI is able to compare large amounts of text to identify similarities or patterns. Another approach is to look at how reliable Tracelex itself considers the results to be. And Tracelex itself has applied scores of 80 and 85, indicating that it's very confident. But the problem is we don't know how accurate the lexigraphs are, and how good Tracelex is comparing one lexicograph with another. And unfortunately, there's no information from Tracelex or the company behind it regarding how it works and how reliable it is. And as Mr. Parry says, we're not even quite sure what these scores of 80 and 85 actually mean. We could have more confidence if the two results produced were clearly connected to each other. I mean, I put to Ms. Brown that the connection is a bit tenuous. She pushed back at that, but it's not and I agree with some of the points she made, but the connection is not as clear as it might be. If you had a really clear connection, that would put you in a stronger position, I think. Dr. Chen's experiments with Tracelex are useful. Based on his experiments, he's found that the accuracy of Tracelex depends on the amount of input text. The more text you have, the more accurate it is. I think a problem in this case is we don't really know how much input text was available. The fact problem says that all advertising material and commentary posted by the account Pure Goods was put into Tracelex, but we don't really know how much material that is. So we don't know how reliable the lexicograph is. And then I suppose the final thing is the fact that the material from the two Reddit accounts and the posts on Pure Goods were compared by the police analysts in terms of slang terms used, word selection, sentence length, and active time periods. And the analysts concluded that it was likely that the Reddit accounts and the Pure Goods accounts shared the same authors. But as Mr. Parry's pointed out, likely may just mean nothing more than more likely than not. And the police themselves have acknowledged this kind of analysis is hard for humans to do. So anyway, those are some thoughts. Where I got to in the end, I thought that both sides put up very strong arguments, and it's very difficult to choose. I think, on balance, I feel that the warrant probably wasn't validly obtained, but I thought both sides put up very strong arguments, and it was difficult to make a decision. And then on the second issue, I haven't spent as much time on this, thinking about this, just because I was told that I should be focusing more on the first issue. But my impression is that the evidence should be admitted because it was obtained in good faith and ultimately it proved to be reliable. But I should say I haven't spent a lot of time thinking about it. But those are my impressions for what it's worth.
Thank you, Sir, for your time and also your insight in those questions. Really interested in what you think as the audience. You've taken the time to come and listen to some very articulate and insightful submissions. Before I put it to a vote. Are there any comments or questions from the audience for our participants? No? Okay. Well, we have his honour's view. Now the people will speak. On the question of really, is it reasonable, I think, in the context of an issuing officer considering granting something as intrusive as a surveillance device warrant, which authorises obviously interception of communications, private communications. Is it reasonable, do we think, to rely upon a tool as opaque as TraceLeaks when considering the issuance of that warrant, and in particular whether or not there are reasonable grounds to believe? The question which comes down to, is the evidence admissible or is it not? If you think it's unreasonable, the evidence is not admissible. If you think it is reasonable, the evidence is admissible. So I'll put the question to you in those terms. Who agrees that the evidence, it is reasonable and the evidence would be admissible? And who thinks it is not reasonable or is unreasonable and the evidence should be excluded? Well, there we have it. We're all more or less agreed. Thank you again very much for coming. Do appreciate your time and your interest. Thank you again, sir, for taking the time to preside over this hearing. Thank you to council for your very able and helpful submissions. Thank you, Andrew, for your time. I thought you were utterly compelling as an expert on a fictitious AI tool. That brings the proceeding to a close. Please join us in the foyer if you would like. Upstairs, downstairs? In the foyer downstairs for some light refreshments. Thank you again for your time, and if you'll join me in thanking our participants.